Okay, so I am very pleased. As you know, we had an earlier segment, but now I have a judge here on the set with me, a friend of mine, Judge Alberto Milian from Florida. You are a judge in the 11th Circuit, right? In
yes,
Florida.
ma'am.
Gigi, one of our guests, Gonzalez, appears, I think, before you. But so we're not going to ask you any questions on her cases. But Judge, first of all, thank you for coming.
Thank you.
You are here not to discuss the specifics of this case, but to talk about procedure in Florida. Tell me about, this case has 6 people as a death penalty case, and my understanding was there was a big fight for years to go to the Florida Supreme Court, make it 12 people for a death penalty case, but came back and this defendant wanted 6. Why is that allowed, and what's the difference in process?
Well, it's very unusual, to be honest with you. In my experience as both a prosecutor, as a defense attorney, now as a judge. And by the way, as a caveat, I don't want any of the listeners to allow anything that I say or do lead them to believe that I would prefer one preference over another in this or any other case. It's highly unusual, though. Usually as a defense attorney, you would want the 12 jurors there because there's more of an opportunity to create reasonable doubt. If you can get one juror to have a reasonable doubt, you end up with a hung jury, which is what happened previously. 6 jurors, it's a lot easier for 6 people to come away convinced and to come to a conclusion. So I thought that was an unusual move, but the judge handled it the way we are taught as judges to handle it. He did a colloquy, an interview with the defendant, asking him under oath, was it knowingly and intelligently and voluntarily? Did he really want to go with the 6 jurors? So I think from a fundamental perspective of as far as covering the record, that's what a judge is supposed to be, and that's what our Supreme Court teaches all judges to do, is to make sure it's on the record so it's not going to be an appellate issue. It could come up after a conviction if the defendant comes back on what's called a post-conviction relief motion, saying this was based on the advice of his attorney and it was a bad tactical move and he would have preferred maybe to go with the 12. But at this point in time, I think they're stuck with the 6 jurors and the 2 alternates, and they are going to be the decision makers. One thing I'd like to say, because when I lecture out to civic groups and even in law schools, I always emphasize something. You know, Chief Justice Roberts of the Supreme Court said nobody ever went to a trial to see the judge, just like nobody went to a baseball game to see the umpire. Well, the most important people at this point in this trial, besides the defendant, whose rights have to be protected, are the jurors. The jurors are the ones that decide the facts of the case. They are going to decide a verdict. Number 1, if a crime was committed, and number 2, if the defendant is the person that committed the crime, and of course, beyond a reasonable doubt. These are things that we as lawyers talk about, but I think the public needs to understand that the judge's job at this point in time is to facilitate and ensure fairness and protect the defendant's rights.
Well, let's see one of the DNA experts for the state, Dr. McElfresh, discuss the mixtures out of the presence of the jury to try to facilitate that fairness that Judge Milian is talking about. Okay, well, Dr. I have to get his name right. McElfresh, okay, is saying there, you know, when you test for DNA, you test different loci, different locations on the gene, you test them. And that's normal in almost all labs. And then you get your genetic makeup from your dad and your mom, 50% from your mom, hopefully 50% from your dad. And those are on the alleles, and on the alleles you'll see different numbers, like there'll be a 7 and an 11 here, and the 7 could have come from mom and the 11 from dad, and that's how they determine if somebody could be a DNA donor, so to speak. So Dr. Priya Banerjee, forensic pathologist, assistant state medical examiner in Rhode Island. There's been a lot of problems lately about defense attorneys and courts not wanting this whole mixture business because it's done from proprietary software. What do you do in your lab, in your medical examiner's office? Do you know?
Sure. I can't speak primarily, but I know that, again, that, you know, at autopsy, we collect all the trace evidence and then it's submitted for testing through the police. And again, I am aware that the lab uses certain modalities that are proprietary to test and give results. I'm not sure exactly what platforms they are, but again, it comes up all the time that, you know, how DNA is so important to connect or disconnect, if you will, disprove whether someone committed a crime.
So if Mr. Segura is the father for the young boy, Javante, who's at the bottom of the pile of the children, it's a hard thing to think of, and his DNA is on the handrail, but he had been there, he says, 2 days before, could that be a transfer in your experience as a medical examiner from the time that he'd been there before, or just not just a transfer, a touching, or a transfer from one place to another?
I think either are potential causes. Like if he was there and he's allowed in the apartment, I think, if it's not being washed aggressively or cleaned, maybe it was from a previous visit, or maybe it was during the commission of a crime. I think that's, hard to say.
So you as a medical examiner wouldn't determine in this case whether or not Henry Segura is guilty because of DNA. You would just give the police and the prosecution the injuries that you found.
Yes, and I think the other thing that we do to connect and help the police is like take fingernail clippings, really examine the bodies, take
and doctor, guess what? Guess what? We're out of time. We have to go to a break.
Okay.
The whole hour
No,
went so fast. I can't wait to have you back again. I'm partial to medical examiners. As you know, I'm married to one, married to forensic pathologist. Please come back. Stay with us here at the Law and Crime Network, and we'll be right back after this. Gigi Gonzalez, I actually laughed when I just heard that. I thought that was a pretty amazing statement. You know, what the heck are you empathizing with me for? It's like, what do you mean you're empathizing with me? I mean, to me that sounded more of innocence than anything else.
Absolutely, and he's got a really cool, calm demeanor here. The officer is clearly trying to peg him into saying something that, gets him to admit, that he's up to something. And the reality is that he's in no position because he didn't have the motive that the police are saying that he had to commit this crime.
And Gigi, one other thing before I go to Judge Milian here. The quality of the video here, you hear, but you don't see the faces. And I think that's really important to see what the faces are. I think that tells at least more of a story that that not necessarily will tell you the truth or not, but I want to see how they're acting.
Human nature is like that. You want to see the look in somebody's eyes when they're telling you something so that you can figure out whether it's true or not. That's within our nature. But here, we don't need that. We're watching this man answer these questions and try to cooperate in a very cool, calm, collected manner.
Okay. And Judge Milian from the 11th Circuit in Florida. Again, we're not going to talk about the facts of this case, but before we went to break, we were discussing what evidence means, DNA or stuff under the fingernails. And Gigi sent to me during the break the case you and I were talking about, Darrell Wayne Hodgkins, state of Florida. What does that stand for?
I think Florida Supreme Court has been very cautious. Yes, we do have the death penalty, and we have over 400 people sitting on death row. But in fact, the Supreme Court of Florida coined the phrase death is different. And in this case that you were talking about was a homicide where DNA was found from the defendant under the fingernails of the victim, who was found beaten to death. And solely on that evidence and other circumstantial evidence, he was convicted, sentenced to death. And the Florida Supreme Court said since the defendant, when he was arrested, provided a reasonable hypothesis of innocence, he told the detectives that basically the victim had always scratched his back when they made love, the Supreme Court said a conviction could not stand. And they reversed and threw out the case completely. In other words, the defendant could not be retried on that particular case because he had now been tried once and double jeopardy applied. So I think the same thing applies for all forensic evidence. Fingerprints. Fingerprints by themselves mean nothing. It means somebody left their prints there. But the prosecution always has to prove at a time that's relevant to prove their presence at the time that the crime was actually committed. And there's another first-degree murder case with fingerprints alone tied a defendant to a triple homicide. And again, the Florida Supreme Court reversed, remanded, and threw out the conviction because there was some evidence that it was a potential drug hit by a drug gang.
Wow,
and so
drug hit by a drug gang.
And those are two first-degree murder cases.
Well, let me tell you, Judge Milian, you're going to have to stay tuned, and our viewers are going to have to stay tuned, because we're going to discuss alternate theories here as to how or who killed Brandy Peters and her children.